Hello everyone. Sorry I had to cut to go back to just work on the internet issues, but I think that's better now. So thank you very much. My name is Juliana Imam, just in case you don't know me. And today I'm going to be covering this session of IPcatchUP. IPcatchUP is basically an interview series where we interview people in the IP space. So we interview legal practitioners, those in the creative industry, those in the innovative industry, research, etc. And today I'm going to be introducing our guest soon. Our topic for today is offensive intellectual property protection. I know that it might sound a bit weird because we are thinking, how can an IP protection be offensive in the first place? But the speaker that we have today is someone who is very vast in intellectual property matters. Aside from IP matters, he's also very vast in legal matters. And so we can ask our questions from different angles, knowing that he would be able to handle it. So please, I would like to know if you can hear me. If you can hear me, please just send in a comment saying that you can hear me, so that I'm sure that I'm not just talking to myself. You can just wave or just send, okay, yes, we can hear you, so that I'm sure that everybody can hear me. So I'm still trying to connect with my guest, Mr. Folarin Aluko. He's a legal practitioner. By the time he comes in, I would read out his profile. Yes, okay, sir. So I'm trying to connect to you, sir. I think it's an internet issue, but I'm trying to connect to you. I have sent a request already, and I hope that the request is getting to you. So I'm thinking, okay, you are here. Fine. Oh, welcome, sir. Sorry, because on my screen I can see it's still going round and all that. So, sir, you're welcome. Please, if you can just speak so I can hear your voice, because I'm not seeing you from here. Yes, I can hear you. Perfect.
Okay.
Okay, sir. Thank you. I think it's maybe from my end then. Okay. Thank you, sir. Thank you for joining us. So I was trying to introduce Mr. Folarin to everybody that is watching with us, and for those that would still watch after this broadcast. Mr. Folarin, that's my own personal introduction before I read his introduction from this place. So I had something to do, and somebody went to introduce me to the former chairman. That's the former chairman of the Nigerian Bar Association, Abuja branch. And he was like, your face is familiar and all that. And by the time we were done with the discussion, we realized that we were both into IP. And right from that time up till now, he has always been very supportive, not just to me, but to IP practitioners and to lawyers in general. Even during the COVID-19 era, he was among those who were at the forefront of sharing palliatives to a lot of people. And aside from IP, he's very vast in different legal areas. And so if you have any question, you can easily just drop them in the chat box. And while he's discussing, we can always ask him those questions. So Mr. Folarin is a legal practitioner and partner in the law firm of Truman Rockwood Solicitors. Get the name. And they provide legal and IP services among other legal services. He is a director of the Intellectual Property Institute Nigeria and a trustee of the Intellectual Property Lawyers Association Nigeria. He's also the immediate past chairman of the Nigerian Bar Association Abuja branch, where they introduced schemes that also promote IP awareness in the entertainment industry and among startups. So I know that he works with a lot of startups and IP in the fashion industry, dance industry, and he does a lot of things to see that the IP industry is broadly spread across and everybody understands what this is. And so our topic today is offensive intellectual property protection. But before we dive into the matter, I would like Mr. Folarin to just share about himself, who he is, how he started, how he got into IP, and just his practice so far. Maybe for the next 2 to 3 minutes before we dive into the main discussion.
Okay, can you hear me?
Okay, sir.
Can you hear me?
Yes,
Thank you
sir.
for
I can
that
hear you.
interesting introduction, Juliana. I don't know what I did to Instagram, but somehow my video isn't coming up. Uh, can you see me now?
I can't see
Yes.
you, but we can hear you
Okay. I
clearly.
guess to avoid tampering with the the settings, let me just leave it like this. Okay. Thank you, Juliana.
Okay, sir.
I'd like to be the person that you just introduced with all those fightings.
More than that.
Uh, but yeah, you just said it. I'm a legal practitioner. Um, I I also practice a couple of other disciplines in addition to law. But I don't necessarily see myself. My worldview is not defined by I am a lawyer. I tend to see myself as someone who provides solutions. So because if you look at the evolution of society and the evolution of career roles, lawyers are required to do much more today than we did just 5 years ago or 10 years ago. And if you go back, a little further, you find that the roles that lawyers played in those days, 20, 30 years ago, were also have also been opened up. And so you have a mix of other professionals doing what lawyers used to do, and so on. And we also get the chance to encroach on the territories of other professionals. So I see myself as a multidisciplinary person. I provide solutions, legal, regulatory compliance solutions, and intellectual property. Yeah, I'm a young lawyer. I'm a young guy. I was talking to someone this morning and I said, I'm a Lagos boy. And he said, Lagos man. And I said, no, I'm a Lagos boy. you know, um, yeah, you mentioned MB Abuja. Yes, I'm immediate past chairman of Nigerian Bar Association Abuja branch. We had the opportunity of doing a lot of interesting things, and trying out a bunch of things during my tenure as chairman. I also had the pleasure and the privilege of meeting a lot of people, yourself included. I'm not sure I'd have met you physically, face to face. I did not been for NBA Abuja, but I had seen some of your content on Instagram. To tell the truth, this is my first IG live session. I do more snooping on Instagram than actual, you know, than using the account. Actually, I use other social media
Maybe
handles.
that's why they are
I don't. Maybe that's
because
why
they're
they're
like,
vetting for me.
so
But I've invested.
you
I mean, for about a year plus, I used, I had an interface. At least MB Abuja is at MB Abuja, on Instagram. So
it's true.
I don't know. But this is my first engagement with my own account. So
Thank you. Thank
it's
you.
it's really a privilege, as my brothers from the East would say. Yeah, so I've had the opportunity of being on different sides of the fence, of the IP fence, as a creator at one point in time in one space in my life, in the music industry. Also as a manager in that industry, and then as a lawyer, and then even as a lawyer, I believe lawyers are also creators. So as a lawyer, I've also had the opportunity and privilege of sitting as working as a creator, content creator. So yeah, so I am also, I wear some caps. As you said, executive director, IP Institute, and what else? I'm a trustee in the IP Lawyers Association as well. Yes, and I love startups. I have some. I had the privilege of being exposed to computers very early in life. So really early in the 80s, actually. I know once if you use computers back then, you must code. So coding wasn't something. It's not coding really. MS DOS. The environment was based on the MS DOS prompt or C prompts environment. Well, yeah, C prompt environment. So you would have to know like a bunch of commands to execute to get from point A to point B. And so that, I think, segued in the early 2000s, just before the, yeah, 99, 2000, during the Y2K hysteria, segued into a short stint with, not a short, it was a very long stint with computer engineering. And so I also I have had a background in that as well. And then somewhere in the late
Okay.
2000s, can you hear me?
Yes, I can hear you. What I wanted to even find out is, do you think that that people who have creative upbringing or creative sides to them um, come out being come out as better IP lawyers? Because most of the lawyers that I've interviewed so far have like a creative side or like a tech side or like an innovative side to them. Like, is
Okay.
there something that pushes people that have those sides that studied law directly to IP?
That's a fantastic question. I see you're trying to, lawyers sometimes talk a lot of you. Yeah. So that's a fantastic question. Yeah, I think a foodie will make a very good chef. So if you know how it tastes, you're likely to be very particular about, the mechanics of making the thing. So, but it doesn't always translate to the fact that one has a creative bent does not always translate to one being a good IP lawyer, or even a good lawyer in the first place. Um, okay, let's go into a little psychology. So, some research has shown that there's a certain, you need a certain, it takes a certain character, a person with certain character traits. They call them if you look at the big five traits, ocean, openness, all those, yeah, the big five. It takes people with a certain type of those traits to gravitate towards the legal profession. It also happens to be that you find people who have a creative bent, studying law. And that's why, unfortunately, in Nigeria, what it translates to is people say, oh, you're good at writing, you're good at debating, you're good at this, go and study law. That was the extent of the guidance counseling that we got as kids. Or that even that is given in, I hope it's much better these days. I doubt that though. So you find that the legal profession gets a lot of people are dumped on the legal profession, people who should be in other spaces in the creative or literary space. And that's why you see, I can count, I know just so many people, from Tosin, what's that his name again? The guy that sang Olomi, to Cobhams, to Sasha, to a bunch of people who ended up in law. I have friends who were fantastic dancers, who are dance directors today, who ended up studying law, and walked away from law. So I think for me, the trick was I had the opportunity early on of consciously deciding what side of the fence I wanted to sit on actively. And I chose law. Yes. So
Can you hear
being
me?
a, yes, I can hear you. So being an
Okay.
IP, uh, being somebody who has used IP and who has created IP has really helped understand some of the IP concepts. But it does go a long way. So in terms of career path, if
Okay.
you're someone who, because I know you also are a creative person, you sing,
Yes, sir.
yes, beautifully well. my voice is very,
Thank you.
my voice isn't as nice. It doesn't sound as nice. But any lawyer who finds that he or she is in that position or is at that meeting point of decision, I think IP is a good
Yes, sir.
choice to arm yourself with.
Okay.
I hope that answers the
Okay, sir.
question.
Thank you. Yes.
Okay.
Yes, it does. So maybe we would be diving into the topic now,
Okay.
which is offensive intellectual property protection. So, first of all, how can an IP protection be offensive?
Okay. Great question again, Juliana. You're just shooting it out. Um, so there's a presumption. The presumption, this conversation presumes that um, one already knows that somebody, the whoever is listening, um, already has, or whoever we're talking to already has some basic knowledge about IP. And so if you're talking about offensive IP protection, there's an assumption that you have an IP strategy, because
Hmm.
your IP strategy essentially is a theory or a plan of action as to how you manage, protect, and commercialize your IP. So it could also include management, can include creation, protection, blah blah blah. So it's how you create, manage, protect, commercialize your IP. So one has to be first of all aware that, okay, I have, this is property, and this is my property. The second thing is one has to be conscious of the nature of the property. So if what you do is you sing, you create work that is protected by copyright, you have to know the nature of the property to understand what IP rights, protects it, whether it's one or it's a bundle or it's several. And so there has to be that consciousness. Now, talking about an IP strategy, we don't all have to be Coca-Cola. Coca-Cola has an IP strategy for each decade, and they've had this for more than, at least, let me not put words in their mouth, but for several years, for several decades. I watched a video
Yes.
about 10 years ago of the unveiling of the IP strategy for a particular decade, and they're very deliberate about it. In fact, somebody boasted in a publication that Coca-Cola, the only person Coca-Cola is not as popular as is Jesus Christ. So that tells us how popular, how the nature, how seriously they take their brand. So if you look at the Coca-Cola brand, they have a brand strategy documentation that is hundreds of pages long. But we're talking about an IP strategy. One doesn't necessarily have to have a document that is many pages long. But the idea is you should have an idea of how you manage, protect, and commercialize, your IP. Whether it's the logo or it's the brand, and there's a difference between a logo and a brand, but that's for marketing people. So, but whether it's the logo, the brand, or it's a musical work, an artistic work, or it's software, or it's an invention that is patentable, or it's a design, for a bag or whatever. So the idea of offensive IP protection essentially is founded in the dichotomy of strategy. So if you have an IP strategy, your strategy will either be defensive or offensive, or somewhere in between. When talking of a defensive approach to IP protection, the first thing you think about is, okay, how do I ensure that all my IP products or intellectual property assets are properly protected? So protection often starts with some kind of registration and all that. But the reality is you can't be offensive you can't have an offensive stance without first being defensive, or ensuring that all your your weak points and weak bases are covered. So that's why I think being offensive or adopting an offensive position is to be preferred to being merely defensive. Um, there are brands that are simply defensive. They just register and keep registering and protect without necessarily going out to stop people from infringing or from using or from diluting their IP. Off the top of my head, I can think of one or two. Today, I had a conversation with my partner in Lagos, and we're talking about uh, a potential client who does not want certain types of exposure. So they have the option of going after some people who have been, who have done something detrimental to them, but they don't want the brand name to be out there that they are the ones doing this. You understand? So you have those types of situations where people don't want some certain types of exposure. Um, but if you look at, let me see, if you look at the provisions of the Trademarks Act, for example, you find that the Trademarks Act contains provisions that there's a section that is actually called defensive registration of well-known and invented words. I think that's section 32, somewhere in the section of use. And like I said, under trademark law, the right to register is predicated on use. So it's either you are using a mark or you intend to use a mark. And that intention has to be bona fide. So it's either you're using the mark or you intend to use it. You intend to use it in the sense that you want to launch a product in the next 2 years, 3 years, 1 month, 2 months, 1 week. And so you say, okay, let me come up with a brand name or a brand logo and we want to register it. But then there are some instances where the Trademarks Act will allow for the registration of words that in certain classes, even when the owner of those words has no intention of using the brands or the trademarks in those classes. And so section 32 talks about defensive registration. And you find defensive registration provisions in the Trademarks Acts of other countries. So, in a nutshell, so we've talked about defensive. Now, what is offensive? How can IP registration be offensive? Essentially, this has to do with the positive, the positive enforcement, taking positive steps to actually enforce the ownership of one's IP, whether it is a brand, software, invention, and so on and so forth. I'll give an example, a very popular example of a gentleman, he's no longer young, called Micro, a gentleman called Micro. Microsoft is very aggressive, they're very offensive, they go on the offensive when it comes to protecting their trademarks and their brands and their software and all that. And a student, I think it was in high school then, by the name of Mike Rowe, Rowe, who was a software guy, decided to register a website called Mike Rowe Soft. And of course he registered the domain and they put something up, and then Microsoft went after him, very very aggressively, and the case became something of a cause célèbre because it drew the attention of, many people who felt, oh, this is a David and Goliath situation. Many people like to side with David in a David and Goliath
Yes.
exchange. Yeah, so at the end of the day, I think they settled out of court. Of course, Microsoft, they had some special arrangements, but that's one case. Of course, in that case, you would say, oh, this guy was just a child and he was using his true name. If you look at Section 9 of the Trademarks Act, it says 918, I think. that deals with words that qualify for distinctiveness. And it says the name of the company and individual or firm, blah blah blah, represented in a special or particular manner. Anyway, he was using his true name. So people would have said, "Oh, that was very aggressive. That was very this, very that." Whatever you choose, however you choose to view it, it is up to you. But that shows how aggressive one can be with protecting their brand. Of course, when it comes to coming to the era of software piracy, Microsoft also adopted a very aggressive stance in Nigeria. And one of the reasons is that you find countries that did not have, I think it took Apple, it took a while before Apple started to export products to Nigeria. I don't think it wasn't it must have been until about 2010, 11, 12, thereabout. So prior to that time, all we had was Windows operating system. And I had a few people who would use Linux, and a few other open source operating systems. But arguably 99% of the computer using digital or technology savvy populace used a Windows operating system. And so Microsoft's approach to enforcing their end user license agreement was to engage the Copyright Commission and then force, have a very aggressive response to piracy, to pirated copies of the Windows operating system, Microsoft Office, and other brands. Yes, so essentially, the idea is that if people know, if competitors know, or if will-be pirates know that your stance is ordinarily aggressive, the likelihood that there will be some infringement, is either minimal. It's actually a very good deterrent, to infringement. It doesn't stop, because bad people will be bad anyway, but there definitely is a huge deterrent factor there. In what ways can one be aggressive? There's the popular Microsoft versus Franike case. I think litigation is one very key area. Also, in the event that it's a trademark issue, and the person who owns the trademark, or the proposed or the infringer or infringing person wants to register the trademark, then your venue can be the trademark registry. Many people also don't know that the trademark registry has a tribunal that sits to decide on trademark dispute cases. Now, the trademark tribunal is a tribunal. The tribunal has jurisdiction to hear matters concerning registered trademarks or trademarks that are in the process of registration. So you can either have opposition proceedings or any other, or there are contentious proceedings, and of course there are also non-contentious proceedings. Contentious proceedings include an application for rectification on the grounds of falsification of the register or fraud. You can also have an application for what we call expungement, where essentially is an application to remove a mark from the register. Now, there are several reasons why such an application may be brought. You can bring an application because the trademark owner is not using it. So this is an application now against a registered trademark or the owner of registered trademark. So you may have some trademarks that have been dumped in the register since God knows when, and have neither been renewed nor used or serviced. There has been nothing has happened. You can apply that be removed from the register on grounds of non-use. Can you hear me? Can you hear me?
Hello, sir. Are you still there?
Yes. Can you hear me?
Okay, yes, I can hear you. Hello, Mr.
Yes, okay, I can hear you. Okay. I think I lost you for a second. It
I can
seems
hear you, sir.
okay. I don't know whether it's your network or it's mine, but um, yes. So you have that.
You
Okay,
can
thanks,
continue the
Max.
discussion.
Max is here. This bad. Okay, so at before the trademarks tribunal, it doesn't have many people think trademarks tribunal only hears opposition proceedings. Opposition proceedings are proceedings arising from the objection to the registration of a trademark. So the Trademarks Act, once a mark has been accepted, then the mark is advertised in the trademark journal. Okay, the mark is advertised in the trademark journal, and then after the mark is advertised, within 2 months from the date of advertisement, any interested party can file an objection or an opposition to the registration of that trademark. See, Max. I beg you, I wasn't sharing palliative. In fact, we are looking for Max. We are looking for our palliative. I need palliative, please. I'm also a palliative hunter. So
Okay, I think you people will keep it in the escrow account.
what's that?
So by the time you give the palliative, then I will hold it in an
Hey,
account
Juliana.
so that I can pass it to the other person.
That's how the Abacha loot was looted. It's okay now. But so
Okay.
the trademark
So
tribunal is to hear
yes.
decisions in opposition proceedings and in other contentious proceedings. So an application for rectification, I'll give you an example of how that can be used. I once was, I don't know, okay, I was once briefed to register a particular mark, and in the process, we discovered that there was a mark with a similar name that had some generic elements, on the register in the same class. But it was a very old mark and it hadn't been used in a long time. So what we did was we first applied for that the mark should be removed on grounds of non-use, But at the end of the day, that prayer was commuted to something else. So he told the register, you know what? The similar elements of the mark are the generic elements, are generic. So we feel you can approve with a comment or with a caution, which was what was ultimately done. So.
Oh, okay. I didn't know that was actually possible. So it's possible to write to the trademark registry that a particular name has not been in use. If that since
Oh, yes.
since there's a duration for renewal and all that.
Yes,
So if you need to use a name and someone else just locks it down, you can write for it to be removed.
Yes, you can. Although I must warn you, non-use applications are very tricky because proving non-use is like disproving a negative. All the person has to do, because the non-use is not using the trademark at the trademark registry. The non-use actually has to do with not using the brand in the market or the mark in the market. So in that sense, all a proprietor has to do might just be to take out an advert in the papers or to do a publication, and that will revive a trademark a mark that has not been used. It can revive it. But the is that
Okay.
trademarks also die, and so a person decide not to use his or her trademark. But the cost, if you consider the cost, sometimes I think some people look at the cost of uh, having a trademark removed from the register, and juxtapose it with, and just consider, what the heck, might as well just leave the trademark there, since trademarks are renewable ad infinitum. But yeah, so non-use can be it's almost like disproving a negative, but there are non-use is a question of fact, and so essentially what you need to bring before the registry will be evidence that this mark has not been in use for a long time. So what you could do, for example, is you can show evidence, bring evidence. So if assuming they
So I'm not sure if the network is breaking for everybody or if it's just my network. Please, if you can hear Mr. Folarin clearly, just help me type that you can hear him clearly so that I would know that it's from my end. But if you can't hear him clearly, please help me type that you can't hear him clearly.
Okay, can you guys hear me clearly? I suspect it may be from your end, Juliana, because I can see the.
Can you hear me?
I can hear you now.
Okay. So based on what you've spoken about already, that means paraphrase what you said.
What's that?
That means in strategy for a particular brand or a particular intellectual property, you can look at it from an offensive perspective or from a defensive place. So a defensive place is when you just do the registration, and after you're done with the registration, you just sit back because you've actually protected it in like different places and you're sure maybe just one or multiple protections. While for an offensive protection, that's when, aside from the fact that you've gone ahead to protect it and to register it. Okay, thank you very much, Mr. Mas and Akin Wale. So for the offensive, that means you still go ahead to, one, you mentioned litigation, two, you mentioned that's the trademark tribunal. So that means for the offensive part, you're not just sitting down to watch, you're actually like being the police of your IP to watch to see if it's infringed upon and then going after it to make sure that the infringers stop infringing on your work.
Yes.
So am I correct?
Yes, that's correct. You also mentioned a very key aspect of an offensive strategy, which is watch services. You're only as you can only protect an infringement that you are aware of as a brand, as a trademark, well, as an IP owner. You can only protect infringements you are aware of. And in when you have a situation where you have a work that can move from one end of the world to the other with just a right-click copy, right-click paste, it is very important that one should be informed. But then watch services don't come for free. They're definitely not free, and so it can be a little pricey. So at the end of the day, one actually has to. There's also a financial element or a cost-benefit element to whatever strategy is adopted. At the same time, people also argue that there's an argument that costs and economic considerations, are not always on the front burner, when making IP-related decisions. They're not always, but because anybody
Hello, sir. Hello, sir. Are you there? Okay. I think this is clearly an internet issue. So I'll just send him a request again for him to join us. I've actually learned a lot so far from just listening to Mr. Flaring about offensive and defensive protection. And I think it's something that is very good because I know that a lot of people just go ahead. Probably they are having cost issues and cost challenges, but they just go ahead to do the protection because someone has told them, do your protection and all that. But they don't really know that, unlike criminal cases or some other cases where maybe the state fights for you, for intellectual property, you have to fight for yourself. You have to look out for yourself, or you have to employ people that would look out on your behalf. And then you have to be the police of your work. So if you're not being the police of your work, then you discover that even though you have these protections, people are still going to be infringing on it. So for me, I think there was a time last year when somebody from Ghana, I think, came into Nigeria and was using a particular trademark that I owned. And so my husband saw it and he took pictures of it, and then he reached out to me that, okay, see, someone is using your trademark. And then we reached out to him and he was saying things like, oh, that his trademark is registered in US. And so that's the reason why he has come into Nigeria to use it and all that. And I'm like, um, trademark protections are territorial, and so the fact that it's protected in the US doesn't mean you come into Nigeria and infringe on another person's intellectual property here in Nigeria. And so we went back and forth and all that. So I think that's just what happens. You have to be the one to look out for people who might infringe on your work, and then you have to act on it. If you do not act on it, no, finally, Instagram has allowed us to see Mr. Folarin's face. Thank God.
Hey,
Welcome,
I'm
sir.
glad. Thank you very much. Yeah. Yes.
Finally,
So,
okay. So I
okay.
was just trying to explain something, but aside the litigation and the trademark
Okay.
registry tribunal, so are there some other ways of being offensive with your IP instead of just being defensive? Hello, sir.
I didn't quite get the question.
Okay, so I was saying that
Yeah, I said I
aside
didn't quite
from the
get the
two that
question. You
you've
said, are there
mentioned,
other ways of?
yes, besides the litigation and the trademark tribunal that you
Okay.
mentioned, what other
Oh yes.
ways?
Well,
Yes, yes, are there other ways? You can continue, sir. You can
I think
continue.
I mentioned I mentioned or I referenced what you said about IP watch services. I don't know if you caught that.
Yes, sir. Yes, sir.
I said I don't know if you caught the IP watch services or maybe
Yes,
network had
yes,
already
sir.
started.
Yes, sir. Yes, I did. I think we're having internet issues, but yes, I did. I hear. Sorry, I heard you before I speak something else. Yes, I heard you.
lawyers can also provide watch services, among other types of professionals. But lawyers, we do it very well. And in certain industries, or with regards to certain types of IP, you are likely to get more information easily. For example, a trademark journal that has all the trademark applications per time, that gives you all the information about potential or will-be infringement in one place. But then there are instances where it's not possible to actually on your own police every instance of infringement. And an example is illegal downloads. So let's say you're an artist and you put your work up on some site, either your own site or it's on a streaming site. How do you stop Pirate Bay, for example, how do you know that somebody somewhere on the internet has not put it up either for free or for sale or for both? So it goes beyond. So in with regards to some types of works, it might be a little more difficult, and so that's where independent watch services come in. For I think I have provided some services where we've had to, or people in the firm have had to do Google searches, for example. You constantly do Google searches to find out where everything shows up on the internet, and so on and so forth. So I think these decisions are decisions that have financial implications, and so you find a situation where the companies that actually engage like third-party services, either for protection or for watch or whatever, are companies that either have an international presence, in which case there's a lot of foreign funding, or they are very large companies. If they are indigenous companies, you rarely find small and medium-scale businesses, taking a very aggressive approach to their IP. And what this actually tells me, or even a defensive approach, if you ask me, what this tells me is that many SMEs, this is for businesses now, and then many individuals, for people generally, most of us as individuals and as SMEs don't really value our IP. And so it becomes a little difficult to look for ways that we can either commercialize or even protect. And in some instances, we have to make a judgment call between publicity, that's the access to the distribution network of the pirated types of work, and stopping the pirate from exploiting or from reproducing the work. So I hope that makes some sense.
It does make sense, actually. So do you have any example of maybe companies that serve as IP watch, that provide these IP watch services, or people should just go and check Google or just type to know companies or firms that actually offer this IP watch service? Hello, sir, are you still with me? I think the internet issue is really bad. But I'll still send him an invite because there are some questions that I think will be good for him to really answer. So I was also thinking of something while Mr. Folarin was talking, and it was about social media. So can we say that social media posts and all that is also part of being offensive? Because we have actually seen a lot of people that their IPs have been infringed on. We've actually seen a lot of people that their IPs have been infringed on, and by the time those IPs are infringed, what they do is that they go on social media and then they talk and talk and talk, and then they have their supporters that also talk about these things, and then some get their solutions and some don't get their solutions. But I wanted Mr. Folarin to also maybe talk about it. So I don't know, should I okay, so I'm trying to see if maybe I can invite maybe if he can join with MBA Abuja. Let me see. Okay. Okay. So I hope that he'll be able to join us, because there are still some there are still some questions I think would be good for. Yes, sir. So can you hear me?
Yes, I can.
Okay. Sorry for the internet
Yes.
issues. Let me quickly ask this question. So I wanted to know, for some people, the way they are offensive about their brands or their um, IP is that they actually go on social media. So if someone infringes on it, they go on social media, they talk about it and all that. And then people that are their fans help them to talk about it. They put it on different blogs, etc. And then people go to stalk the person that is infringing on it. So does it also fall under offensive protection, or people should just go and get their lawyers?
I think that is some kind of self-help. Um, and so what you mean is putting the infringer on blast, essentially,
Yes, that
on
is what
social media.
happens nowadays. Yes, people take their issues online, and then their fans go ahead to terrorize whoever is infringing.
Whoever. Yes, but the thing is, okay, so I also have an interest in like social media, and the I'm interested in the conversation around, social media, and then the reality of maybe a need for social media regulation of some sort. What the situation is in the US, the Communications Decency Act, and so on. Because this question kind of touches, on all these different areas. First and foremost, um, the the law frowns on self-help, and then of course asking people to attack someone, for whatever it is actually some kind of self-help, even if it is, cyber self-help. Um, and so what should ordinarily obtain is immediately you notice or observe that there's some infringement. Immediately one should get a lawyer to issue a cease. With your cease and desist, you can also indicate, and yes, that is one way to be aggressive. Like I'm not sure if you caught this, for the network cut us off, but I was saying something about having to choose between um, infringement and the publicity that comes with infringement. So, for example, in the music industry, at a time, upcoming artists, would rather have an Alaba um, pirate, pirate their music and put it just so that the music could be distributed to a larger audience than that artist, at the time. And so, with regards to other types of that situation, as a reality, that you may have to choose between, okay, can I tolerate this infringement? Especially in the era of cyberspace, um, primacy. So I think what you just mentioned, like doxing people, that kind of stuff can actually be termed as cyber bullying, harassment, and maybe stalking. And if you look at the Cybercrime Prevention Act, which I should say applies only in the FCT, and can only be enforced by federal agencies. But if you look at the provisions of that act, you find that this type of conduct will amount to some kind of stalking, even if what preceded the what predicated the action was actually illegal, an illegal or an unlawful use of somebody else's work. And the reason is uh, social media is the new public square, and in when you are in a public place, if someone does something to you, if there is an assault, if someone hits you or slaps you, that's battery or assault, whichever um, terminology you choose to use. The proper response is not to retaliate in kind, because the minute there's a retaliation, it becomes something else. It becomes affray, or public. What do you call what's the offense that police like to charge people with now? Public nuisance. It becomes something else. So what you should do is you should take notes, and then report. I'm not saying that's what I'm not advising that in the event of a fight, you should start looking for how to report. First, safety first. But for the first thing you should do is to report. And so, in the event of infringement, the first thing you should do is to report, because with IP rights, the law says where there's a Latin maxim that says where there's right, there's a remedy. This has been upheld in several cases. It's what we call a trite saying, ubi ius, ibi remedium. So essentially, where there's an IP right, there's a remedy for infringement, and there's a procedure or a process for getting that remedy, for infringement. Sometimes you also find out that the remedy, the cost of it may be impossible to even get a remedy. I'll give the example of the author, very popular author, Nigerian author, was one of the first to launch a book on WhatsApp, to launch an electronic copy of a book. And when I saw the notice, the announcement that, he was launching the electronic copy on the same day as he'd be launching the physical copy, I asked myself, why? That didn't sound very smart. And the gentleman launched it, and before the end of that day, about 3 or 4 different people had posted that book, the electronic copy, on different WhatsApp groups. And it was all over the place. WhatsApp was even fairly new then. It was all over BBM, as BlackBerry Messenger. It was everywhere. It was all over. The people were saying, "See this, download your copy now."
Ew.
And then the next day, the author came out to complain. And I said to myself, why would you do that? So that was clearly it was a wrong decision. But then the question is, how do you enforce that? There are ways of tracing, but by the time you look at the cost of, and juxtapose it with the possible remedy, one may just have to call it a day. And talking about remedies, I think one of the reasons why Nigeria continues to lose out on quality engagements, in terms of media space, is because our regulatory and enforcement environment is very, very, our environment is very poor. Our systems are starved, and they are almost ineffective. We have good laws, but the systems are practically ineffective. And I'm not talking about, because IP is a private right. Many people think IP is, and that's why this idea of offensive protection is very key. A lot of people think IP, that is the government's responsibility to protect the intellectual property, and so you hear musicians not protecting our intellectual property. The truth is, IP is a private right, and like all private rights, it falls on the individual to protect it. It's the individual's responsibility. So it's your responsibility to protect your intellectual properties. Like, you buy a plot of land, the first thing you do is to, well, may not be the first thing, but at least get documentation, and then probably build a fence, and start to develop the plot of land. So a similar, it's metaphorically speaking, one has active steps to protect his or her. So I think there's, on an international scale looking in, or from an international perspective looking in, there's little confidence in our systems, and specifically the judiciary and the quasi-judicial agencies. For example, the Copyright Act, and I'm not fully in support of a police state, but the Copyright Act provides for copyright inspectors. When the Copyright Act was passed, copyright inspectors, because printing presses were very large things, so there was the recognition that, okay, you needed people who go into buildings to inspect compliance and all of that, likelihood of infringement on an industrial scale. But today it's more a lot of infringement takes place in cyberspace. Yeah. Yes, it's online, but we don't have copyright inspectors. And it's probably I think there's some politics surrounding it, so let me not go there. But these are sections of the act that can be used to serve the public. Unfortunately, we find that's not the case. So that it's a failure on our part, and it's a failure that translates the lack of confidence in our institutions, especially both locally and internationally. And so you find a situation where, for example, we only have one, but we have one active satellite transmission DTH company in Nigeria. That's MultiChoice. We have just one. There are a bunch of other DTH or satellite providers, or all sorts of media outside the country who can serve our market. But the first problem of how do you ensure that, because they trade in content, and can you hear me?
Yes, I can hear you, but it's breaking on my end.
It's breaking. Oh, okay.
Yes, on my own end. I'm not sure if it's central.
Okay. Content is like the what's it called? The common denominating factor in that industry. So unless you are assured that the process of resolution is speedy, the process of registration is equally fast, and hitch-free, you're likely to have, that's by resolution, I meant dispute resolution now. You're likely to have a huge amount of distrust in the system. I'll give you
an
example.
Because I was actually,
Yeah.
Actually thinking of some of the hindrances that people might have, or what people might be thinking of when they refuse to go offensive. So even if they have a protection and they've seen that it's clearly been infringed on, they might be thinking of like the cost to actually go ahead to proceed with it, cost of paying a lawyer, then the time frame that it takes to maybe then go from there to maybe mediation, arbitration, going to court. So then again, even in court, they're still thinking of how long it will take and then they are thinking of the corruption in the system, meaning that you might be going genuinely while someone else might be ready to bribe their way through some of the people that are supposed to make decisions for you. And then there's also the lack of awareness generally, as you said, that the IP, intellectual property is a private right. So where people think is public, they might just be waiting somewhere, hoping that someone else will come to their rescue. And then there's also the where we have people that might feel that they should pray about it, or they should put the picture or the name of the company in their Bible or their whatever, and actually make those people to be to stop using their work and all that. And some will just call and shout and all that. So these are just some of the things like off the top of my head that I'm just thinking that might make people not to really be offensive generally.
Well, as somebody once famously said, if you want to know the cost of knowledge, try ignorance. You know,
True.
So looking at that the conversation, taking it from an economic perspective again, you know, it's quite clear that that there are economic considerations that must be put in place before choosing, you know, the type of strategy that you want to adopt, whether you want to be aggressive. I remember in the early 2000s, Style Plus was very aggressive with fighting pirates, for example. They were extremely aggressive. And there was a time when, I think for about a year or two, any CD that you saw, any Star Plus CD that circulation was a genuine CD, was a genuine article. So it all boils down to what the value of one's IP is. You know, so yes, there's a cost element, but one also has to, I mean, at this point for me, if anything worth creating, you know, if you can take the time and effort to create something, then you should have a global outlook in terms of dispersing whatever it is that you created. So that has to do with the general cost-benefit analysis. When looking at ancillary costs, so if you want to break the cost into components, the cost of legal fees, for example, I think everything boils. I think today you will find lawyers who are willing to work with you at your budget or are willing to grow with the brand, unless the potentials of, well, I said brand, unless of course you don't trust the potential of your IP. But I think cost is a relative factor. The more important considerations, which have to do with the length of time and all that, I think are very key. I find that with IP cases, to a large extent, unfortunately, you find many of the hindrances, you know, in litigation often are caused by the lawyers. And I think one of the reasons is that many people don't really understand, you know, how IP litigation works. So you have a situation where, for example, little things like the forum, somebody is challenging the use of a picture and they are citing the Copyright Act, and then you go to a state high court. You know, that's a problem. Or if if you had a contract with someone, a modeling contract, for example, and pictures were used and blah, 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 you go to the state high court. That's also, if it's copyright and it's a federal enactment relating to copyright, you have to go to the federal high court. Now, people also assume that anything that has to do with IP must be docked at the federal high court. That's also wrong. What Section 251 of the Constitution says is I think if I may quote, it says, I think that should be F or so. It says any federal enactment relating to. So the use of the phrase any federal or the prefix any federal enactment means that if you have a state enactment, or a state law relating to any of these areas, then the Federal High Court will not have jurisdiction. Of course, if you look at the exclusive legislative list, you find that the National Assembly has been given the exclusive legislative, whatever, over copyrights, trade names, trademarks, and so on and so forth. But that's the proviso to clause F of section 251, which says, I just pull it up, any federal enactment. That's very key. So it's not every IP case that must be docked at the Federal High Court, for example. So that's an issue of venue. These are like threshold issues. Other issues such as framing your claims properly. If there's infringement, there's a way you frame, your claims. There are some things that must be in your pleadings. You must plead some things. If it's trademark infringement, for example, I've seen a trademark infringement brief where the plaintiff did not even mention the trademark registration number of the mark
Okay,
trying
that's
to.
serious.
Yeah, I've seen a cease and desist letter that did not contain. You just said, take note that you are infringing on our trademarks, our registered, and I was like, what? You didn't cite the trademark number. So these are problems that actually are caused by
I did not.
brothers and sisters. Yes, and
Okay.
yeah, it's true. And these are the things that often lead to prolonged cases. Of course, you also have issues in the judiciary, courts not sitting, lengthy adjournments, and so on and so forth. But if you have I have done some cases that were concluded, quickly. In fact, in one of the cases, the judge was saying, I've never seen a case where the defendant is the one that is pushing for the case to be concluded. Because in that case, we actually were very aggressive as defendants.
Okay.
And so you find that, and that's because the plaintiff started to, pussyfoot and slow walk. So you find that there's always, it takes two to tango. When talking about the judicial issues in the judiciary, like slowness and all that, yes, it does exist, but there are two sides to that coin. Most times, unfortunately, and I have seen some cases. There was a case, the Olotire case, for example. We shouldn't go into that, by the way, but I saw that I think somebody was saying that someone had filed something somewhere, and I'm like, okay, this is quite interesting. I would like to see what the claims are, and yeah. So I don't think the problems are insurmountable. There are problems, yes, but there are also ways around the problems. And
Okay.
there was this case. It was a custom case. I won't mention the case since I think it's still live. The case had been on for about 5 years. I was in court when it was mentioned. Like 4 years plus. And I was like, what? Is that allowed in life?
Yeah.
What's the case doing in court for 4 years, for 5 years? So these are things like that. And when I looked at the pleadings, I understood why
Why?
it had taken that long. I
Okay.
understood
Someone
immediately.
someone here asked a question. Akinwale Daniel. He said, "Sir, are our IP laws adequate in addressing IP infringements through online medium?"
Okay. Our IP laws are sufficient, not adequate, but they're sufficient. And I'm borrowing from the doctrine of adequacy in contract law, of sufficiency anyway, in contract law. And that's taken from the theory of consideration. Consideration does not have to be adequate, but it must be sufficient. Sufficiency doctrine says it must be something of value, And so my answer to that is our laws are sufficient. We have laws that protect, IP. The problem is in the enforcement of the laws, and by enforcement, I'm not also saying this is not a shout out to government. No, it's more of a shout out to the citizens, to you and I, because we don't use the laws in the ways that we should. So the problem is enforcement, and then of course there are some structural problems. Yes, like I had mentioned, we talked about the copyright inspectors. The copyright inspector has the power to enter into a premises to inspect. You can't do that without a warrant. If you're a policeman, to do it without a warrant, you must have witnessed the commission of a crime. There are very limited number of circumstances, but then copyright inspectors have these wide powers, and that would also apply to cyberspace. The reality is that, in my opinion, we don't need laws we don't need a special set of laws for cyberspace to regulate, quote and unquote, where we don't need additional regulation. The law of libel still works. The law of defamation, slander applies. Copyright, the same way, if you infringe on someone's copyright, physically, in the physical world, it's the same thing, you do it virtually. The same laws still apply, and they're sufficient. What our laws need to address are the nuances, in which, cyberspace, the cyberspace infrastructure operates. And by nuances, what do I mean? When signing on to, we're on Instagram now, you're signing on, Instagram has its terms and conditions. That's a set of laws. There's this very interesting article in the shadow of eBay law, and it looks at dispute resolution and what the overarching legal principles are in cyberspace on eBay. But in this case, we're actually operating under the laws of Instagram, because Instagram says don't harass, don't threaten, don't dox, don't do this, don't do that, don't engage in that. If you break the law, you'll be sanctioned. But then the question is Instagram not a company? And then how does a company get to regulate, what you may call cyberspace? Because this is the public square. Yes, it's their platform, but they've also been given a lot of leverage by governments, to operate. So with great power comes great responsibility, and so I think legislation should look at issues of privacy, issues of course, intellectual property related issues. But when it comes to policing intellectual property online, I think our laws cover the field to a large extent. Yes, I agree that there are some shortfalls. The laws did not contemplate a number of things. Today, when the Copyright Act was passed, to run a Xerox, to Xerox a book, you would have to take it to a place where they had Xerox machines or a printing press, and then print it. People didn't have Xerox machines in their offices, just as a machine. But today, you right-click, copy, right-click, paste, and
Yes.
you've created, multiple copies. But it's still the same. It's the same principle. The unlawful use or unlawful commercial exploitation. Now, I think another area where our laws, where one may need some clarity in our laws, would have to be in the definition of concepts.
Okay.
But social media is still new, so things like what is commercial usage? How do you define commercial usage in the era of sharing? There's a button that
Okay.
says share. So someone who is sharing a poem, for example, is that person infringing on the copyright of another person, of the poet? If the original person who posted it
Yes.
without
Cover songs, all that.
authorization, yes, things like cover songs, stuff like that. What's the how should the law respond? But I'm not quick to say that we should think of regulation, because you and I would agree, if your song goes viral on TikTok with a dance, you are likely to see a corresponding increase in your Spotify streams, your iTunes streams, and other areas. So you see an
Yes.
increase in revenue somewhere else. If your song goes viral on Instagram with covers, you're likely also to see an increase in streams, in revenue. So the conversation around what amounts to infringement, or well, let's not say infringement, let's say commercial use and non-commercial use, you know, requires a lot of thought. So there definitely is a need to have, a very robust conversation. But because these concepts are fresh, they are still evolving. I remember Napster back in the day, and then from Napster to LimeWire and the other sharing apps. You know, some courts held that in the US held that file sharing at that time was legal, even though it was non-commercial, non-profit. Then you had the DMCA, the Digital Millennium Copyright Act in the UK, which further strictened or made, well, it streamlined the definition of non-commercial use of copyrightable works. But the question, like I said, to a large extent, if I click share or someone sends me a write-up on WhatsApp, and now WhatsApp has created a way to know that something, there's this set of arrows that says has been forwarded many times. I don't know what use,
Yes.
whether it's how useful that is, but it shows you that this thing has gone around. Now, if I share it, what am I doing? Am I infringing? You know, is that use to be allowed in the grand scheme of things? So these are conversations that I
Okay.
think we need to have. But
Sir,
I think our laws are
I know
sufficient.
if I should allow you, we might talk here for like long hours, and I don't think that Instagram um like gives more than like an hour, 15, 20 minutes. So
Oh, I
they
see.
might cut us off anytime soon. But
Oh,
so far, like you've really talked intelligently, and like for people would have to listen to this video again to be able to get all the concepts that you've mentioned, because you've spoken about different things that fall under this offensive IP protection and all that. So prior to this time, I was not even sure of like defensive, offensive, and all that. And I'm into IPO, but like listening to you, I've seen like all the things that you've mentioned, and then the litigation and the IP watch actually. Though I've heard about it somewhere, but I was not sure of how effective they are. Although I know that there are bodies that, but you might need to pay that would help, that can help you serve as like an eye to look out for your um IP stuffs, etc. So let me just tell our audience and for those that will be watching later that if you need to continue this conversation or if you need to ask more questions, you can check Mr. Folarin out on his Instagram handle at FM Aluko, or you can check him out on not on Facebook. I'm not sure he's on Facebook, but he's on LinkedIn.
I'm on
Yes.
Facebook, but
So
I'm not very active.
okay.
But yeah,
So
I'm
you
on
can just
LinkedIn
check
and on Twitter.
LinkedIn, yeah. Twitter, yes, Twitter. So if you have any questions, you can just feel free to reach out to him. And he's a very nice person. So he would at least give you the initial answer before you now pay for your consultation. So,
Mhm.
sir, please
I
help
also
us with a
promise
sum.
I promise to start using my Instagram.
Instagram.
Yes, I
You
promise to
see
start
how
doing
long
more
it
work
took
on my Instagram.
them to show your face. They wanted to tell you that use us more, use us more.
Mm,
Okay, sir.
um,
Thank you. So, just help us with
thank
a
you.
summary, and then we can end the session.
Okay. So in summary, whether you're an IP user or an IP manager or an IP, expert in some other way, either as an IP lawyer or if you provide any of the value chain services in that IP space, it's you should have a strategy. There should be a
Yes.
strategy for every type of intellectual property. Like we said, it's either defensive or offensive. But I think we're coming to the place where you must have an offensive policy or an offensive strategy, especially under the AFCFTA, which opens up the whole of Africa, to everywhere else in Africa. So you have the likelihood of a diffusion or a dispersion of brands. You're going to have a much tighter battle in terms of brand wars and so on and so forth. So I think SMEs should engage and look for a lawyer. I don't think lawyers cost as much as people think we do. It's not cheap, but if you look at what you're likely to gain, in the long run, we're not expensive. So I would encourage people to talk to a lawyer, engage your lawyers, and yeah, it's February. Have a fantastic 2021. I'm actually looking forward to creating more content in 2021 and exploiting that content myself. So I should say a big thank you to you, Juliana, for putting this together. Fantastic stuff. Thanks to everybody who
Thank
has joined. I saw Max. Anywhere you say IP like this, you see Max there. Fantastic guy. Thank you very much, Juliana, for having me.
Thank you. Thank you very much, sir. And thanks to everyone who joined us. Sorry for the internet issues that we had, but I'm sure that if you are patient enough, you can still go back and listen and learn something from what was shared today, because the person that spoke to us today is our Baba. So what I,
Okay.
for those that are not Nigerians, is like, somebody that is here and is like a big uncle to a lot of us. So thank you
I'm
very,
very
very
told.
much,
That's
sir,
why I'm
for
here, because of you.
sharing so much, and for everyone who listened. Thank you, Mr. Max. Thank you for the other person also, for Daniel Akinwale too, for your questions. And this session holds every Friday by 2 p.m. So you can easily join us on Fridays to watch it, or you can check us out on YouTube by the time the videos are transferred there. Thank you and have a lovely day. Thank you so much, sir, for saying yes.
Thank you
Thank you
very
for
much.
sharing your
Thank you,
knowledge.
everyone. Thanks,
We
Max, and thank you,
appreciate you.
Akimani.
Thank you, sir. Have a lovely day, Mr.
Thank
Folari,
you.
and have a lovely day, every other person that followed us.
Bye.
Thank you. Bye.
Bye.